Hello. Welcome to Be My Own Boss podcast. I'm your host, Mike Hruby, and this is episode 51. Today we are celebrating is too strong a word, observing the 87th birthday of the Fair Labor Standards Act, the major federal law that governs all labor relationships between employees and employers and affects all of the state regulations on labor. But the best we can muster is a grumpy 87th birthday FLSA because it's still hurting freelancers and it's not doing anybody any good. It's not helping freedom. It's not helping the economy. It's not helping individuals. And it's not helping business. So what happened 87 years ago on this date, June 25th? Well, the unions sent a long, complex bill to to Congress, and Congress debated and passed the Fair Labor Standards Act and sent it to the president over a lot of objections with the problems with what the Fair Labor Standards Act established, which was minimum wage and working conditions and standard things like time and a half. What is now standard is time and a half and a 40-hour work week. And you can say those are good or say those are bad or see drawbacks in them. But it eliminated private choice and private negotiations for salary and working conditions of exactly the type that now is becoming really important for independent contractors. So FDR signed it, and on this date, June 25th, it became law. And then it was fought through the courts. And you've seen recently what fought through the courts means. It's a lot of commotion and legal back and forth and uncertainty for all parties. And finally, in 1944, with a decision named Wickard versus Filburn, the Supreme Court found a way to accommodate President Roosevelt's threats and passed said that the law, FLSA, is legitimate and constitutional. We'll talk further about Wickard versus Filburn, another interesting topic, and how it directly affects independent contractors. But what went into effect on this date, 87 years ago, was a very large. I have a copy here. I had to bind it. It's big. It's thick. It's many, many pages and clauses long. It has 19 sections of what was then brand new law in labor law. And they mention a world of different subjects all in the same piece of legislation. They mentioned children. They mentioned child labor. They mentioned unions. They mentioned boards. They mentioned fishing. They mentioned different kinds of fish. They mentioned overtime and work week length and interstate commerce and salesmen and motor buses. They have inspections and exemptions. It talks about canals, vehicle towing, students, the handicapped, people with serious injuries, and the canal zone for reasons that aren't immediately apparent, all in one bill that now is one of the biggest impediments to independent contractors' freedom and economic freedom and personal freedom. And its weaknesses are rarely discussed in public. It has, at 87 years old, it just continues to do its damage. There's not a lot of interest in Washington for changing it. There's no knowledge among the public that there is even something called the Fair Labor Standards Act, and if people know anything, it's they know the name and not much else. But the insight that every independent contractor needs to keep in mind is that American common law, which is the law of judges seeing cases, reviewing cases, and applying the law as they see best fit. It's our usual law. American common law accommodates individuals who are accepting important responsibilities and rights. The best example I can mention is marriage. The law, American law, accommodates marriage. It allows you to make that choice yourself. It doesn't force you to change it. It doesn't force you to wait. It says, all right, you want to get married, you get, in this case, you may get a marriage certificate, you have to pass some blood tests. All of that applies to marriage, and you get rights and responsibilities, and everybody who's married knows what those rights and responsibilities are, or they used to. And everybody understands that. If you accept military service or have it imposed on you, you accept rights and you accept responsibilities, and the law accommodates that. The law will enforce performance on either side, and that people respect that. If you operate large equipment, if you handle the power supply, if you provide food or beverages or manufacture them, all of those are higher levels of rights and responsibilities, and the public and the government respects them. But that doesn't apply to independent contractors. So if you as an independent contractor or I wish to do project work and to make our income or part of our income by project work, it says no, we don't have any capability of acknowledging that wish. You have to be an employee, you have to have a boss, you have to work a 40-hour week or whatever you agree that's less. You need to get time and a half if they're overtime. There's all kinds of other in complexities imposed on you and your buyer, which is an employer. All those complexities are imposed without your being able to say, wait, I just want to do project work. You have a Social Security number? Yes, but there's no self-employment identification number. So the law mistreats the income stream that 76 million Americans now use for some or all of their income. And this is a gross failure on the part of both federal and state legislators and on the part of labor law. And this problem has grown considerably more intense for more than 60 years. The acceptance of the responsibility of working for yourself, of finding work, doing it, completing it, and then moving on to something else has not been accommodated. And it recently got worse when Biden put in end of 2024, when he put in a new regime. It's a very complicated scheme. It just built on the Fair Labor Standards Act and made it even harder. So now, in the last 3 years, the blue states, we call them maybe left-leaning or left-voting states, are putting in even worse laws into effect following a variation of the Fair Labor Standards Act. And I'll give you California AB 5 and all the hullabaloo for the last 5.5 years about that law. That destroyed millions of jobs. They're trying to do a similar thing in Massachusetts with legislating mandatory unionization of drivers and rideshare and food delivery drivers. New Jersey is putting in an impossible to follow, to comply with law. They're considering it literally this week. Rhode Island made using an independent contractor a felony with the express purpose that they can go after employers in any state and drag them across the state line. So there is all kind of mischief afoot in the states, and it's all based on more than three major weaknesses in the structure of the Fair Labor Standards Act as to how it deals with, how it doesn't accommodate individuals who want to work for themselves. And I'm gonna mention the most important three, partly because we're going through these weaknesses, the lacks, LACKS, the things that are lacking in the Fair Labor Standards Act. They're so important, and yet almost nobody knows about them. Literally, probably fewer than 100 in the whole country are actually genuinely aware of this problem. So the first one is there is no way for an individual to choose the status of independent contractor. You want a fishing license, you go get a fishing license, and then you've got the license. You can't just go be an independent contractor and get a license. They can't register it, you can't certify it, you can't elect it, you can't do anything. You can't say that. No, they say there's no way to do that. And there's nobody working except Be My Own Boss podcast and Mike Hruby. Nobody working for that to become the solution. But it is the solution. We will eventually get there. The second lacking item is that there is no objective test of what is actually an independent contractor in the law. Imagine speed limits where instead of they say school speed limit 20 or highway speed limit 65, you had school speed limit slow. Like, how does that work? How do you have a non-objective law that people's lives depend on, and you call it slow or fast? Well, how does Montana distinguish from Colorado and go 70 miles an hour because their roads are bigger and open and fewer curves? You can't, like fast? What is that? How do you tell it to slow down in a business district? How do you people... It's an engineered number. You can tell by looking at the street what the number should be. But if you didn't have a speedometer on your car and a speed limit, people would be crashing all over the place. So we need an objective test. And then when it comes time for that objective test, here's the third missing piece, the lack, and that is that labor law measures the wrong relationship to talk about rights and responsibilities with. A self-employer is both a boss and an employee for himself. It's a dual nature, and there is that in the law. There are things with dual natures, but it measures the wrong relationship. Labor law measures something they call the employee-employer relationship between a buyer and a seller. When I go into a store, I go into Home Depot, and I buy from them. I'm not their boss. They don't report to me. I'm just paying for something. The same with your clients. They're just paying for something, a ride or a solution or a puzzle or a piece of artwork or, some problem solved, plumbing. That's the relationship is between, that the law should be looking at, is between the individual doing the work and that person choosing the responsibility and the right to work for a limited length of time on a project and then go elsewhere. Pat Benatar said, what is it? Thrill me and then go home, go away. And that's what project work is all about. Thrill me and then go away. That's fine. I understand that. I've lived well over 20 years of my adult life being self-employed, and that has never bothered me. I don't feel the worse. I don't feel that I'm missing something. I just go get a bigger, better, more interesting job and keep going on a project and keep going with that. So you can do 7 or 8 of them in my business at a time. So you don't ever want it to run out. You never get fired. You can only come to an end of the project. So those 3 things we've been discussing recently, no way for an individual to establish a choice, no objective definition of what an independent contractor really is, which is crazy because an independent contractor is someone who wants to be one, and measuring the wrong relationship. Again, it's between the individual and their work style choice. And every one of the independent contractors who is voluntary in this country knows that. 76 million people. We have got to make this clear. We choose this. We love it. It's the only way we can do it. We've got kids, we've got a schedule, we've got taking care of grandparents or kids or relatives or doing things or balancing act or working nights and weekends. We've got a million reasons why. Our commitment is to do the work this way. And labor law, the Fair Labor Standards Act, needs to accommodate us. It's a demand. We can't live without it, and the economy can't live missing 76 million people, particularly now on the very exciting prospects of freer growth. So, again, if you'd like to hear more about these topics, please comment in the thread below the recording on YouTube. We're discussing a series of these weaknesses and the different aspects and how to fix them. This is a fixable problem that just nobody cares to fix because nobody's worried about you getting mad that they're not doing it. There are a lot of ways to convince people. You don't have to get mad, but you have to be heard. So independent contractors really need to pay close attention. Washington is going to try to pass 2 bills at the same time, and then they're going to go, yep, that's it, we fixed it, and you want to be there saying, nope, there's more to this, and here's what you didn't do. But until they hear that there's more, they're going to say, no, I didn't hear that, no. We can do it. Your freedom to work for yourself is very much at risk right now. And the Fair Labor Standards Act is the cause of the problem, and that's where the solution will have to come. So here's to a grumpy 87th birthday, FLSA. We hope you learn better, stop hurting freelancers, and let's get out there and fix it. So thank you. This has been episode 51. We'll see you in the next episode, and leave those comments at the bottom. Like us, subscribe, and we'll see you in the next episode. Thank you.